It's a great privilege and pleasure to return to Turkey for the third time and to join so many distinguished friends, as well as, I hope, new friends. One of my newest friends, I hope, Dean Hakkari, expressed surprise when I mentioned to him last night that I was familiar with the very broad definition of terrorism in Turkish law, at least until earlier this year. In the United States, Turkey is regarded as very important, and the rule of law is regarded as very important to our relationship. That's why so many of us from the United States and elsewhere have traveled so far to attend this conference. In the United States, we know, or perhaps misunderstand, I could be corrected in the next few days, that this broad definition of terrorism, at least until recently in Turkey, has included propaganda as a form of terrorism, expressing views that are consistent with the views of terrorist organizations. 1/3 of the terrorism prosecutions, 38,000, 1/3 of those 38,000 prosecutions for terrorism since 9/11 have occurred here in Turkey. And there are more journalists, it's reported, in jail or prison than in any other country of the world, perhaps because of these statutes. We know, not just from media reports, but from scholarly articles, that there are controversial prosecutions, Sledgehammer and Ergenekon, which have evidence, the authenticity, the reliability of which is seriously disputed, and only Russia, I understand, has more cases in the European Court of Human Rights than Turkey. I think that makes it particularly impressive that you've organized this conference and invited us to come and talk about our experience, but also to learn from yours. The basic point of my talk, which I did write out, and I'll try to abbreviate it somewhat without confusing the interpreters too much, is that every single person in this room is very vital to the future of the rule of law in his or her country and in the world. In the United States, it's long been said that a democracy is a government of laws and not men. However, as the United States Attorney General, the chief prosecutor of the United States after Watergate, Edward Levy, for whom I worked as a young man, said in 1975, "If we are to have a government of laws and not men, then it particularly takes dedicated men and women to accomplish this through their zeal and determination, and also their concern for fairness and impartiality." Protected by two oceans, the United States does not have a long history of combating foreign foes or terrorists on its own territory. Its commitment to the rule of law has nevertheless been tested whenever the nation has felt threatened. And as I will explain, this is my principal point, the historic leaders of the United States, who are now most respected, have been dedicated to assuring the humane and fair administration of justice in dangerous times. The terrorist attacks on September 11, 2001, have challenged the rule of law and civil liberties in the United States as terrorism does in every democracy. In 2004, I gave a talk at Harvard reflecting on how the United States was responding to that challenge. I didn't talk to Professor Green about his speech today, but I called that a judge's reflections on the battle against terror and talked about why calling it a war against terror was really, in my view, inappropriate. But I began my talk at Harvard by discussing my first visit to Turkey. And here's what I said. In 1991, at the request of the American ambassador, I helped conduct a human rights conference in Turkey for members of the Turkish parliament. Then, as now, Turkey was an important ally of the United States. However, the Bar Association of the City of New York had recently issued a report finding that the Turkish government had been arresting people for thought crimes, particularly expressing sympathy for the Kurds, keeping them in incommunicado detention, meaning they couldn't speak to a lawyer or their family or anyone else, for 18 days, torturing them, then bringing them before a judge and a doctor who each certified that they had not been tortured. On the first day, I went on to say, I spoke to the members of Parliament about the evolution of our First Amendment right to freedom of speech, our Fourth Amendment right to be free of unreasonable searches and seizures, and our Fifth Amendment right to due process. On the second morning, the members of Parliament were very animated. They told me they had just been watching CNN and seen a man named Rodney King being beaten by the Los Angeles police. I reminded them, I said at Harvard, that I had not said that the United States was distinguished because it is perfect. Rather, I said the United States, like every country, is imperfect. However, it is distinguished by its commitment to the rule of law. I urged the members of Parliament to watch what happened because I was confident that they would see that the Rodney King matter would be dealt with seriously and properly in the courts of the United States. And I'll say now that the policeman they saw on CNN did eventually go to prison. But I also said in my Harvard talk in 2004, since 9/11, I have often wondered what I would tell those Turkish members of Parliament today. American citizens Yasser Hamdi and Jose Padilla had been held for years in incommunicado detention in the United States, not 18 days, years. In addition, the president had been advised by his attorneys that he had the inherent authority to authorize torture, despite Geneva Conventions and other U.S. laws that prohibit it. In essence, I was saying at Harvard in 2004 that I would have been perplexed and probably embarrassed if I had been invited and come here to give this talk in 2004 about my country. This conference, however, has provided a welcome opportunity for me to update my reflections, and particularly to put them in a historical perspective. As many, if not all of you know, based on the English Lord Acton's axiom that power corrupts and absolute power corrupts absolutely, the Constitution of the United States creates a government in which the executive, legislative, and judicial powers are allocated to three separate branches of government. The media is widely regarded as the fourth estate, or the fourth branch of government. Freedom of press is protected by the First Amendment to the Constitution because we understand that such freedom is essential to having the well-informed citizens who are the foundation of any democracy. In my Harvard talk, I criticized the then Attorney General of the United States, John Ashcroft, who had asserted that those in Congress, the courts, and the media who expressed concerns about lost liberty were unpatriotically giving ammunition to the United States' enemies and pause to our friends. As I noted, this attitude was completely contrary to what Judge Learned Hand correctly characterized in the middle of World War II as America's spirit of liberty, the spirit which is not too sure that it is right. In my talk, I also noted the extraordinary efforts of the President, my college classmate George Bush, to keep Congress and the courts from performing their constitutional duties and to frustrate the media as well. With regard to the courts, the President had taken the position that judges did not have the power to limit his authority to conduct war against terrorists. Among other things, the President had asserted, upon the advice of government lawyers, that extreme techniques, such as waterboarding, did not constitute torture prohibited by the Geneva Conventions and United States statutes. He asserted that American citizens characterized by the President as terrorists could be detained indefinitely without any judicial review, and he claimed that United States statutes and treaties did not apply to detainees at Guantanamo, and therefore American courts had no authority to apply American law there. Such responses to 9/11 will seem familiar to people from Turkey and many other countries with longer histories of combating terrorist threats to their very existence, a threat the United States did not and does not now face. However, in 2004, the United States Supreme Court rejected the President's contention that a United States citizen accused of being a terrorist could be detained without judicial review, and that United States courts did not have authority to decide if the detentions of aliens at Guantanamo was lawful. The power of an independent and impartial judiciary to review and restrain executive action in a time of terror is very important. As I noted at Harvard in 2004, when they were tested in court after 9/11, many of the government's most sensational terrorism charges could not be proven. I listed 6 cases between 2002 and 2004. One involved an Oregon attorney who was released after it was determined that the Federal Bureau of Investigation had erroneously matched his fingerprints with those found on a bag connected with the Madrid bombing. In another case, 2 Muslim men arrested in upstate New York in an undercover operation involving the sale of weapons to alleged terrorists were released after the Justice Department admitted it had incorrectly translated some key documents. All of the examples I gave illustrated the importance of presenting highly charged allegations to a fair form of adversarial testing before an impartial judge, in our case, in our country, a jury. When monstrous crimes have been committed, there is an understandable impulse to hold somebody responsible. This pressure magnifies both the risk of convicting the innocent and the importance of an adversarial presentation of evidence to an impartial decision maker. I ended my 2004 Harvard talk by discussing the one true threat to the existence of the United States, the War of Independence, which was fought to separate America from Great Britain. As an acclaimed American historian had then recently written, in 1776, leaders believed that it was not enough to win the war. They also had to win in a way that was consistent with the values of their society and the principles of their cause. One of their great achievements in the winter campaign of 1776 and 77 was to manage the war in a manner that was true to the expanding humanitarian ideals of the American Revolution. It happened in a way that was different from the ordinary course of wars in general. In Congress and the Army, American leaders resolved that the War of Independence would be conducted with a respect for human rights, even of the enemy. This idea grew stronger during the campaign of 1976 to 77, not weaker, as is commonly the case in war. And that historian explained that in 1976 and 7, the Continental Congress established legislatively a policy of humanity that was articulated by John Adams and put into military practice by General George Washington. Although the British treated captured Americans brutally, Washington prohibited the torture of captured British soldiers and indeed ordered his army to treat them humanely. As the historian correctly concluded, these moral choices enlarged the meaning of the American Revolution. George Washington and John Adams were later elected the first 2 presidents of the United States. As the immediate response to 9/11 indicates, the United States is challenged to remember the wisdom and courage of its founding fathers and does not always or promptly succeed in doing that. However, as I indicated earlier, the Americans who are most respected by history are those who have worked hard to do that. The First Amendment to the United States Constitution, which was adopted in 1789, prohibits Congress from making any law abridging freedom of speech or of the press or the right of the people peacefully to assemble and to petition the government for a redress of grievances. It has been a battle in every generation to give meaning to that guarantee. For example, in 1919, an anarchist detonated a bomb at the home of the United States Attorney General in Washington, D.C., as part of a plot to explode bombs in cities throughout the country. The Attorney General characterized the bombings as an attempt to terrorize the country. Later that year, the United States Supreme Court decided 4 cases which upheld the convictions under our Espionage Act for what is now rightly regarded as political speech protected by the First Amendment. It's now widely recognized that those decisions were wrong. For example, in one case, the defendants had merely urged people who had been drafted not to join the military. They were convicted. In the 4th case, the Supreme Court affirmed, meaning upheld, the convictions of several refugees from Russia who had distributed leaflets protesting President Woodrow Wilson's decision to send American troops to Russia after the Bolshevik Revolution. Justices Oliver Wendell Holmes and Louis D. Brandeis dissented from this decision. Holmes explained that the United States only had the power to punish speech that creates a clear and immediate danger of serious harm, speech that is both intended to incite violence and is actually likely to do so immediately. Under this test today, an order from a leader of al-Qaeda to a suicide bomber to destroy his target would not be speech protected by the First Amendment. However, an imam's sermon promoting violent jihad would be protected if there was only some general risk that it would encourage an unidentified individual to act. In 1927, in another dissent, joined by Holmes, Justice Brandeis explained the principles on which freedom of speech in America is based. As Brandeis wrote, "Those who won our independence recognize the risks to which all human institutions are subject, but they knew that order could not be secured merely through fear of punishment, that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, and that hate menaces stable government." Therefore, Brandeis concluded, America's founders amended the Constitution so that free speech and assembly should be guaranteed. Because many of their colleagues succumbed to the passions and pressures of the times, Holmes and Brandeis originally were in the minority. However, their positions on speech have become the law of the United States, and Brandeis and Holmes are now remembered and revered as the great dissenters. In 1940, Robert Jackson was the Attorney General of the United States. He would go on to become a distinguished member of the Supreme Court, an architect of the Nuremberg War Crimes Tribunals, and the chief American prosecutor there. In 1940, foreign foes were making many in the United States frightened and insecure. Jackson urged his prosecutors not to be influenced by those anxieties. As he said to them, in times of fear or hysteria, political, racial, religious, social, and economic groups, often for the best of motives, cry for the scalps, for the death of individuals or groups because they do not like their views. Particularly, do we need to be dispassionate and courageous in cases which deal with subversive activities. Those who are in office are apt to regard as subversive the activities of any of those who would bring about a change of administration. Subversive. Therefore, Jackson told his prosecutors that in the enforcement of the laws which protect our national existence, we should prosecute any and every act of violation, but only overt acts, not the expression of opinion or activities such as the holding of meetings, petitioning of Congress, or dissemination of news or opinions. Only by extreme care can we protect the spirit as well as the letter of our civil liberties, and to do so is the responsibility of the federal prosecutor. In 1950, the United States' commitment to the rule of law was again challenged by a national sense of insecurity. In 1949, the Soviet Union had exploded an atomic bomb, causing many Americans to fear a devastating nuclear attack. A lawyer who worked in the internal security section of the Department of Justice Judith Copeland was arrested while passing stolen classified documents to a Soviet official. Copeland's attorney suspected that the warrant for her arrest was based on information obtained by an illegal wiretap. However, the trial judge refused to disclose to Copeland the records necessary to determine whether this was true. Copeland was convicted and sentenced to serve 15 years in prison. On appeal, her conviction was vacated. It was overturned. It was obvious that Copeland was guilty. She'd been caught handing the classified documents to a Soviet official. However, in the United States, we believe that achieving even the most important end never justifies the use of illegal means by law enforcement, and a defendant is entitled to the information necessary to test whether the evidence against her was lawfully obtained. As Judge Learned Hand explained in vacating Copeland's conviction, few weapons in the arsenal of freedom are more useful than the power to compel a government to disclose the evidence on which it seeks to forfeit the liberty of its citizens. All governments, democracies as well as autocracies, believe that those they seek to punish are guilty. The impediment of constitutional barriers are galling, disturbing to all governments when they prevent the consummation of that just purpose. But those barriers were devised and are precious because they prevent that purpose and its pursuit from passing unchallenged by the accused and unpurged by public scrutiny and public criticism. He concluded, a society which has come to wince, a society that does not want to look at such exposure of the methods by which it seeks to impose its will upon its members, has already lost the feel of freedom and is on the path toward absolutism. The people I've mentioned, George Washington, John Adams, Oliver Wendell Holmes, Louis Brandeis, Robert Jackson, and Learned Hand, are among the most famous of American heroes today. However, the United States has also been fortunate to be served by little-known, perhaps unremembered heroes as well. Women and men dedicated to assuring that law enforcement is fair as well as effective, even in times of terror. As I said earlier, in 2004, the United States Supreme Court rejected President Bush's claims that Americans he deemed to be terrorists could be imprisoned without judicial review, and that aliens detained at Guantanamo were not protected by United States laws enforceable in United States court. However, the Supreme Court was not required to decide whether waterboarding, and comparable interrogation techniques violated United States statutes and treaties prohibiting torture. That is because in 2004, a young law professor named Jack Goldsmith, not well known, became the Assistant Attorney General for the Office of Legal Counsel, a position often characterized as the president's lawyer. Goldsmith reviewed his predecessor's legal opinions, advising the president that he had absolute power to decide how captives would be treated, and found them to be without any legal foundation. They were wrong in Goldsmith's view. Goldsmith similarly concluded that an important secret national security agency surveillance program was unlawful. Therefore, Goldsmith told the president and his colleagues what they did not want to hear, but they felt compelled to respect, and the unlawful practices and program were ended. As Edward Snowden's revelations concerning more recent national security agency surveillance programs remind Americans, the challenge to commit the serious threat of terrorism effectively, lawfully, and with respect for civil liberties never ends. In the United States and in the countries represented at this conference, that challenge calls for lawyers and judges who are inspired to extend the highest traditions of our profession, exemplified by the bravest and the best. I hope that history will judge each of us to have met that challenge. Thank you very much.